was a man, and Marco by Enfamuna, Sedea Etea Nie Edumedie. So, your friend Dachi Nana Yao Asante on the elbow rings of my Cobra Sante, Dominic Bois, and a Medina Monemo at the Edumedie at the Abreu. Only say Supreme Courts really on the issue because the Nankrofwa dream was so and Nipa would work the air classico and for a possible the cross examination between the petitioner and the first respondent and the attendant no court at the abasa and yadia and Marabia Emma Hokanse was Mammy Aduko Mensa a Jina. The
Society of Laws case like this petition also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are amended to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64 Clause 1. Challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
Ruling in the Abba, and Professor Sia cancer found, sir, Yakokota, Yakopre, sir. Yepe justice and so emrani bi wo ho a akwako ye ne se any justice no enhyeda amoibra na nayi yepe se ye ni a lawyer kuku dama ono wodi mra na nim a check akra eni ye di nkomo unim lawyer GaryNiamko legal practitioner private one kra je se wono ankra na je se wodi wonsem edima won ye ni ntwetwe nkomo no ye misa no sympathy na emra no ene justice no ana prepare ye no sen nsunsu yempen na edantem na yatumi anya emu adefia lawyer ma
nya me joso na design
ani ado e dia boko de
de akani akrakra
lawyer
nso won design
twede ampa dawo ma ye ho ye lawyer say ye kase justice any law nsunsu yebe na da ni yen ntem
yo amencha tiefo metie o program nyina na before I answer question no friend free baby nkodu baby asembe na si e wo man mo asembe si nyina na se yakoto aba na no ye to aba no na Ghana fo nyina fancy yakodi ahia yakodi die kills ni anya to aba ye to aba wi no obi an complain say aba yakoto ye no sebe obi also otoba ne amana ntubi obi an complain say na ya management anyomodwuma obi an complain say record ya mo ye wo polling station college centers regional centers ekoya ko nyina no ebia asembia ba ho ana achinya ba ho election na kasa na ekotu ye no ekodi kiro we are complaining complain about the say that collation and so declaration by EC chair and na eda court any idea ba asemo and say EC chair obo aba no ebi say about boy no why mistake and ntino eda ko gina court. That is what is before the court. Menua ye ma no be clear o man mo say o just say kugina court wa, and this thing let me take my time to explain. No bia ntiase wa kugina court no ko bo nkru e kire court ko court wa tro no sem nyina go krata so asem esi ye nie esi da sei we kan nyina uwie a wo say onyina so enie evidence enie evidence be free ifa e be free wa wo de court na kasa ho ana say bia wada se fo a wo from say wo be kebima wo a wo hu de wo hu ye say de court so no omo hu ye be di adanse da ma wo we go do court wa wo ye plaintiff and now wo ye petitioner in this instance we nso a ye wo the other side or a defendant and as a case we say there or a respondent the case we letter commissioner return officer no or a respondent just only yi wasama no second respondent so nipa of benefit here from the elections yura Nana Akufo-Addo or no and a second respondent isi mo dwuma wi yura your mama say election koye no edikan area no okada bontin say they will not accept results of a flawed elections yentie ne ye pa o menua see yentie se mo say ye we will miss all the issues before the court abontin no ka kire nyina Ghana say election no de Ghana for the mandate no amano eno ntino se results no ye declare amfa ma no dia ene onyin tumo because results no ebe ye flawed results because Ghana for nyina say mandate no e dia man I don't know change NDC for executives national executives me bo bia din wa ebe kan share na say election no dia eye yewra mama on our one election no na change yet demonstrations okroma bebrebe ni nyina e dey bentia say election no yewra mama won it the one election ni wie no sabi EC chair o chinchim NDC for nsa chinchim mama nsa e dey agena ma yewra Nana Akufo-Addo. There was burning of ties in this whole country. There was noise making all over the country. Obia they said there be election on Tiasi, including members of parliament say election in the NDC now 1 year, Mama now 1 year, and Untino, and Yadium Batiasi. He declared Mamo. These are the background antecedent to the case before the Supreme Court. I don't call Koya name because there be. Yamu de hwemrana di oba ho say yemra hodwuma wo de kata kamera hwa wo say mra hodwuma ne yewa hwemrana mu fichi ya wo say to aba na wan tie ase a ba bia witimi akọ wasem e Supreme Court anu ti no e wo say Euro mama tie ase de a obeku Supreme Court e did mo after all the yi aye chiri nyina wo wie no mfa le Supreme Court o file Supreme Court no ade ne nyina yehwe as lawyer for and they say the card abonten no say election no Euro mama win no ko wu Supreme Court no o mon ka say election no so Euro mama wa win e na eye EC chairperson ma me Jemesa echinchim ne nsa e de agena ma Euro Nana Akufo-Addo udu court wan kan sa udu court say election no obia win election no nemum yenko round 2 ana say na no ya wo say election na win ye emma wa won crofo including some members of parliament and some who are even senior lawyers in this country say President Mama only declare no parallel government
or the part aba
na all run the parallel government e bona onye so
wapa hocho yes
e ho de kasa asem no boni di na metie oya lawyer ni panyi okroma
yes
oya member of parliament okroma
yes
we say won declare parallel government ye ba for republic you also be declare parallel government okroma say that but only declare parallel government because they believe say based on your internal collation no Euro mama election wa winning and na Euro mama Jemesa echinchim ne nsa e dey ama Euro Nana Akufo-Addo do court I was election obi an winning
but for the purposes of the records no nsema ye de court eno na e wo court is here and the omudi kan outside they say ye na ye win by the can say ye na ye win ye hwe mama comfortable lead odi so nya de ade nyina no it never appeared in court the court is here
me mom yakọ
nyina nya the trash
nyina nya no mechi mom yakoduro important say Ghana fo be hunu sebe case e court no say the si hye na de do the see na de ekono nyina no chichi mom hunu so you see the trend analysis of what I'm building. I'm taking my time to build the thing for you. And on that chain, go to court no. And now, I feel asam no de di kan be me fe no nyina me de na hu hia. Say no, asam na kasa hyase.
Yes.
The hyase no, and now we file witness statement. What the for? Obodi adanse ama wo. Yewura say di ketia. Yewura pesa white. Edi kan buy. Normally, the litigation require any piecemeal. Omo bekasa ma onyina no, obi akasa ma obi atwa na de ma owie. Twoma owie a na o kodoke so. Edu so bekasa omo bekasa. You say the tebe sha daka mu. We na tie ya ko wie ya na se. Tintin nyina na se. Court na busa na se. Eja, we say if the figures were right. If the figures were right, and yeah, it means somebody crossed 50% plus 1. The figures in your right there. Actually, say you recover across 50% plus 1. We say if means a condition, just say a no credit. Then the court asks you residing it here. Now what kasa. It was up. Which are key internal coalition? Say na wunya ye as figures are political party musakai. My lord, I know the anywa. Minya. What check your figures no be no. Say na you reku for dunya ye. My lord, I know the anywa. Minya. The figures no the figures no. And I could in a court. So what did you go to court with? You could do court no. And figures are the coach in the court say obi any who winning ye no. Obi a winning no. Figure no see in crowd. E ni nsem ho. Tu ko the court. Ko ye den court. I thought say I was saying ka yewura ese ni ketia. E de enkrata che say nobody obtained 50% plus 1. E de court nanim. That's your evidence. That is your evidence. Say me nyina so nie obi no nya ye. Copy sheet no obi a obi. NDC will be. NDP will be. Party executive nyina omo nyina copy sheet bi. The copy sheet no a carbon copy of wow agent or center.
Yes.
Sebe original ko isi wono. Omo assign also the waje odi edeko. As a matter of fact, about 30 say 16 regions in no, and this is for sign 13 of the regions. Which means that they have the copies with them. So one pass a million copies no one China. Between 9th of December, declaration you buy. Are you telling me, say, no queen and enemy? A year petition of we and I end the political party. Omu nink of four, I can't number say boom. I mean, some number say, nya, no, the nya in ye. Na penny and pa, near pa. The nya no. As a matter of fact, it's a fact. Nobody obtained 50% plus 1. A bit the moment I go to court anymore.
But lawyer, looking at the case before the court, will it not be in the interest of justice, sir, even class NDC and to me and prove, say these were the figures that you know, yes, you want to be provided. Yes, and it's a want to be provided in the interest of justice.
What justice?
Yes, the justice we seek at court because you say, "Udi asem eko court wa ye hwe emrenu ni akaso asem we say and was ye dane ye buama." In the interest of that, no. Once you say anka electoral commission anka say or answer certain questions nanka in the interest of the general public
answer question bay. That's the first question. Answer question bay because you see, let me also take you through the process. Until say Yura Chachikata, a close in the case. No? There was no subpoena. Because subpoena and Shekrata what filed before the court. Actually, say, me here say the pass mercy and now bentin a wadakem because say the pass mercy and now bentino. Agreement or a material witness before the court. The court no and financial dakem MIA. And let me distinguish this from what is going on before the court. Subpoena no court na issue o failure na court jitumwa. Court ashe ayen she say wo ni pass mercy and now benten. And that's it special dakem. Yen to one. Because we a material witness even for the court. Now nipa miensa ana afra mo wa dwene mu no who lay the foundation of your case wa dwene mu no you are discharging the burden on you as far as civil cases are concerned tira friend nipa miensa be wasem ma wo wa dwene mu no who say wa kan case wi until no you have closed your case when you close your case it means the case no abawi here. What same no what can we? I don't know. What can we no? Now the other side no say also open defense. Me boy na. I'm so yeah you know there. The okay can hear there. It mean me defense be because if it's a one can we. And then what can we there? Win the case on the strength of what you have put before the court. With the strength of your own evidence, win the case. It's Yankasa. And there's nothing wrong with that. There's nothing wrong with that. Because you see, like the court rightly opined.
I say, Emranuma
Hong Kwan said, Untimi for so Ubia were your party in the case. Sijinachi on Kasa.
Say impose a Goban said Nipanos or Kasa, you could help the court to be able to make a decision.
To help the court to do what?
To make a decision on the case.
Oh. If the party says, I will not talk. The court cannot compel the party in a matter to talk. Let me explain to you why. Akwa se wako jina odi abu ko jina nsuo. Na wo se abu no no nsuo. Na wo bo abu ne tiko pan se no nsuo wo se me no nsuo no so bo no nsuo by force. Ebe ye za.
Right.
Me no metia esi yi. Na wa kire me. Ho odin si mi ntino. Bomo sum ba ko wa pan na me hwe odin obo another one pan me hwe odin me se me nkasa o chinchin akasa because my boss sum di kasa by force me se me nkasa the waka nyina no wa dwene mu no o prove case let it go I be clear say you right to get chikata the party of from so me ye nyina so me nyina enya dia on na dwene mu no o wi the case. Do you buy that? I don't think they say no send yes or file a paper to now reopen the case. A case that you have closed. A case that you have put your witnesses inside. You want to now see the court leave to reopen the case.
Say legal. So bet me a process is all bet me.
We will see how the Supreme Court will deal with it.
Will you buy the idea?
Because you see, under normal circumstances. What by your case, case management. What file with the statement? If my friend Parado say, my friend Parado say, who we are, a restaurant about once a month, what under evidence in an was within who we are, who close to case you are, what's the matter? Mr. Menkasa, and by force. What's I'm saying, you know, the court must now look at the evidence of the and enter judgment for you if you have won the case.
And the process is being you are to set your cancel or person or reopen the case or bet me a reopen case.
One our first reopen case now. And the obectuary rules go or the reopen case now. It do yeah,
lawyer, will you buy the idea the Nkrofo Billionaire can say it is to say the Supreme Court is trying to shield the woman.
The Supreme Court is not shielding anybody. You see, the Supreme Court is guided by the Constitution of the Republic of Ghana, by the Supreme Court rules itself, and all the amendments, C99, ABA, the applicability of CR 47 in the Supreme Court rules, which is the High Court rules. Supreme Court no is guided by time. It Kroma say, and who say a coalition petition, I could do 8 months. And I'm going to CI, and the better says, she say a coalition petition. Yen expeditious hearing. The court is guided by all these authorities. The court is guided. And I'm saying, before the case was closed by the petitioner, if they are anticipated, say they will need Jemensa as their witness or as a witness of the court, they ought to have filed the subpoena before they close the case. You don't close your case. I feel that's open leave of the court to now reopen the case and then now file the subpoena to now put the person in the witness box. Because before you see litigation, no, a tactical operation. Litigation, a tactical operation. You sit in your room like a boardroom here, and you plan. How am I going to go about this case? They do it as number one witness, because normally, no, you put your best foot forward. I believe, say the best foot forward in NDC, no, I hear say get here. No shada kem. So my shada kem make case no more. Obeshe mu no. When Timmy and for one figure and put on to her, say, yeah, collation, no, figure in any. Come in the power, say, they've done the collation, and I wouldn't pass, say, the woman, no. Somebody got 50% plus one. They know very well. Because if indeed they knew, say, nobody got 50% plus one, they will have put the figures in.
Do you want to say, Boapaye? Because, pitch the cry this before, no. They're not a crime MP before. They cannot two different pin sheets because they all come copy pin sheets. They all come copy pin sheets. They crowd, you know, because as a originally, we shall see. The air trauma won't yet chama wono, and not yet chama wo, not yet chama way. It cannot be different pin sheets. It can't be different pin sheets. So at this stage, you know, and are you telling me, say, at this stage from December 9th, in fact, before even December 9th, when the numbers kept coming in, and this one the justice regions with one collation paper. And you know, they have not put together all the pin sheets to determine, say, pin sheet, no, say, sister, no, you are your man, more than 50% plus one, and now, so at the time now, almost elections, no, you are your mama now, no. What was the basis for that statement? Let's get it clear. At the time now, almost your mama now election, no. What was the basis for that statement? Say what when it. At the time, I said the will of the people was being subverted. What were the figures I would do on the Casa? Was it just propaganda talk? Was it just mere talking or mere speeches? Or indeed, it was premised on the pin sheet so collated by NDC in their internal records? Lawyer, in court processes, at a point in time, the petitioner filed for some interlocutories.
Yes.
Ekoban said the respondent in open defense on that said those questions anka one train nanka in cross examination yes. I remember very well say as at the time I no more argue those things in court some of the judges are no more ask the questions say those questions anka want to mean train nanka in the midst of cross examination anka won misa. I want to believe that the decision of the judges to set aside that interlocutories on the premise the respondent say in cross examination those questions can be answered, and so judges a ruling and answer a ruling and no decision on that premise and I say at the latter part of the case now the respondent said I will not put my witness in the box. Is it not supposed in a way? Sorry. Say a DCV, judges, I've given them that ruling just to go back and dodge that.
Every rule of law in our procedural rules, or how I see invoke, or how I see apply, or how I court is ruling on it. Every rule. What's the question? Question was I answer no order. It was a question. My question where the Panama answer is there already in the answer of the person. So why they need to ask that question? As a way, mommy, already containing the answer the person has already given you. Was it were there errors committed or whatever? I said yes, it was error. It has been corrected. So what answer again are you looking for? It was there. Also, me here my back for interrogatories. Me here documents way, me here document way, me here pin sheet way, me here original way. When you have a copy, you see, a copy of an original is as good as the original, unless that you are raising genuine questions of authenticity.
And the lawyer, for the first electoral commission at me about Bontin in their response to the petition, can say yes, they've admitted said there was some mistake. They've admitted there was some mistake. It's
public knowledge.
Yes, and the
question of
yes. So the fact said
wait. The question of admitting said there were some mistake. The mistake being instead of saying total valid vote cast, they say total vote, whatever they call it. That means they added everything. They are correcting them. What is the big deal?
Lawyer, by virtue of their rule, are you by chance saying that the mistake was grammar and not numbers?
No, the mistake was numbers. It was numbers because you see, why it was numbers? They say first one, I'm you shooting in a. But what they were a whether A or B, none of them changes the fact that say His Excellency Nana Akufo-Addo obtained more than 50% of the valid votes cast.
Is it not also a case? Say the Constitution no more and that's the Manama of say Nipaninya way you need to declare. That's a ba abontin ever declare. That's a figures I would declare doesn't appear to say the what I would declare and I would declare. If you make a correction based on your declaration, now we say the Bible to Abontia. Will it not also be right? Say you use the same vein I would declare the first one to do the corrected one.
Anyway, I'm going to some choice. One credit card thing, one year, be messy in this matter, and they say you must look closely at the petition and ask yourself questions. Is there a challenge in the validity of the elections itself? Ghana forgot to banana.
No.
Is there a challenge?
No.
The validity.
They never challenge the validity of the election, but the declaration.
Well, look at the Constitution. Well, say you must come to Supreme Court to challenge the
validity of the elections. Yes. So one would ask the question, say per the petition, if it is not challenging the validity of the election, then case management level, none and concern Supreme Court throw the case away.
I don't say, America's in the job. Sometimes, you say, I could be on one, ABA or Petition, and things are out managing in the. I think we'll also Petition. Supreme Court here, court bad time, or a court brand name. Or a court of can be, or a policy court, or a court where, say, what the show mining in a judiciary show. The court to you say, what's a bar? Say, do, say, you do. Once a man, maybe we all my phone, and now Papa Phobis woman, they stomach everything. To hear the question now, what you say, court no is stomaching a lot of things. If you watch the proceedings carefully, because the application that court anymore now I won't say assembly does not disclose any reasonable cause of action.
Yes.
Now if you go court now we release a plenary legal objection now. The court takes that application first. The court need here. Court need here. Now ampa. If the test about the constitutional test is about validity of elections. But you are in court saying declaration, not validity. Now they are even talking about auditing. Let's audit the work of the EC chair. If it's about auditing, are you in Supreme Court to go and do auditing of the EC chair?
Yankopon, I shall. Yeah, what that's